which I'm hoping if you've sort of found our event, you sort of know roughly what the LSS is. But basically, we're sort of like a student-run association, and we're here, I guess, for anything that any law students might need. I myself, as an introduction, I am a second year JD student, about halfway through, definitely ready to be done. That's a whole other issue though. But otherwise, in my normal grown-up life, I'm a dispute resolution officer at the Telecommunications Industry Ombudsman. So I guess a lot of my job is looking at complaints. They are telco complaints, so a lot of them are ultimate first world issues, but looking at complaints and making recommended outcomes on, I guess, the merits of each thing, which means I spend a lot of time writing nice, logically structured documents. Otherwise, just because I'm a bit of a busybody, I'm also a member of the SSCC for the JD. I'm the LIV student ambassador for RMIT. So if you've got any questions about the Law Institute of Victoria, hit me up. Otherwise, just as a quick roadmap for this evening, I'm going to go through how to sort of structure memos and letters of advice. A lot of the slides have a lot of text. Really sorry about this. I really hate that when lecturers do that. But if you've got any questions or something's not making sense, or just overall, it literally is just insane, just let me know. But otherwise, we will go through IRAC really quickly. I know a lot of your lectures will probably harp on about IRAC quite a lot, but it's sort of, I structure my assignments in a similar way that I would my exam answers. So that's why we sort of touch on IRAC there, because it's a really great way to just clearly go through what we kind of need to target in your answers. But yeah, if at any stage something doesn't make sense, let me know. It's going to be fine. Okay, there we go. Just very quickly before we get started, I will do an acknowledgement of country. So we'd like to acknowledge the Wurundjeri people of the Kulin Nations as the traditional owners of the land on which the university stands, and we pay our respects to the Indigenous elders past, present and emerging. Sovereignty has never been ceded. It always was and always will be Aboriginal land. All right, let's get started. So introduction slide. I'm going to look over here, so I do apologize if I'm not looking at the camera. But basically, the overall structure for your letters and your letters of advice to your clients and your memos will look something like this. So you'll see with a letter of advice, it's going to be addressed to a client, and it's going to give them some information about what they need to do next. Versus a memo or a memorandum of advice, that's usually going to be a little bit more formal, and it's going to be advice to usually in-house counsel, a colleague, or like a barrister or something like that. When you're writing to a client, it is going to be informative, but it's going to be, you're not going to use overly legalistic language, because if you do, you're going to lose your client and they're just going to have no idea what you're talking about. Whereas if you're giving advice to, a senior partner or a barrister or something like that, they know what law is. They also use the same, legalistic language. So you can be a bit more, precise. Otherwise, in terms of the structure for both of them, you're going to be using headings and subheadings to sort of guide where we're up to. If at any point it doesn't make sense, let me know. All right, so where do we start? This is super basics, but I'm going to go through this because people forget. I forget, it is what it is. But when you first start your assignment, you want to read the instructions, and then you want to read them again, because chances are you probably didn't read it right. This is so you can clearly identify what the assignment is asking you to do, and so you can make sure that you're actually answering what the lecturer has set out, because it's all good and well to produce a lovely document, but if it's not what your lecturer asked for, it's going to be a waste of everyone's time. Once you've read the question and you think you have an understanding, I would encourage you to go ahead and reread it again and highlight and start making some notes. Personally, I like to print out my assignments because obviously I don't like the environment, but do whatever's easiest for you, just whatever makes sense to go through and pick out all of the key issues and all of the sort of like niggly little things that you're kind of like, oh, that seems a bit odd. But otherwise, At this point, you also want to make sure that you're having a read through the marking rubric, so you can have a bit of an understanding about what they're sort of expecting in your answer. Assuming it makes sense because everyone's nice and quiet. Otherwise, we're going to move on to collecting information. So hopefully at this stage, you've read and you've understood your assignment and it makes sense and you're like, yes, I've got this, and you're ready to start sort of collecting all of your information that's going to go into your recommended into your assignment. At this stage, I mean, the first dot point says about writing at this stage, it's up to you. I normally don't. I sort of dot everything down so that I've kind of got everything and then I can make it make sense later. But if it makes sense to you to start writing, then just start writing. But otherwise, I would encourage you to just sort of get an understanding of what information you need and how it sort of relates to, I guess, the answers that are going to be in either your letter or your memo. So at this point, you want to start by identifying the areas of law that might be relevant in the problem question. I'm going to use contracts as an example just because it's easier and I like contracts. But for example, if you've got a problem question in contracts, you might be looking at whether there's a contract. Next, you kind of want to identify the issues of the law that kind of come up in those areas. So for example, if you are, trying to identify if a contract has been formed in your lovely contract assignment, we might be looking at whether, there's been offer and acceptance, consideration, certainty and intention. So all those kind of elements of contract formation. At this stage, if you're sort of looking at your problem question and you are just really stuck and you're like, what the hell, none of this makes any sense, and you absolutely can't see any issues in the problem, this is definitely something that happened to me very recently with a constitutional law assignment. But if you're really, really, really stuck and you've got no idea, I would encourage you to download all your lecture slides, and if you haven't already, and go through them slide by slide and see what you can pick from your assignment in the lecture slides. Basically, lecturers aren't going to teach, they're not going to test you on something they haven't taught you. So chances are they're going to be asking you about something that's going to be somewhere in your lecture slide. Or depending on what your study group is like, have a chat with your friends. Just to be clear, definitely not saying you should collude with your friends. That is enough to get you kicked out of law school. But there's nothing stopping you, using the LSS Facebook groups to form study groups, and then finding someone to sort of chat through an assignment with. Otherwise, I will say, although it's great that many of you will have separate areas of knowledge, if you've come from a different industry and, for example, there's a lot of people in the JD with medical degrees and stuff like that. For example, it's really unlikely that your torts lecturer is going to ask for like your medical opinion on a medical negligence question. So if you're sort of looking at it and you're like, I know how I would answer this as a doctor, probably not appropriate. They're probably just asking for what they've taught you. Otherwise, a good rule of thumb, if it's not mentioned in the lecture slides, you probably don't need to talk about it. But otherwise, we then want to see if there's any sort of sub-issues. By sub-issues, I sort of mean, what you want to identify the other issues that might come up under each issue of law. So for example, if we're talking about acceptance in the instance of a contract, you might want to talk about, did the offeree communicate acceptance, or, was there silence? And then you kind of want to cover, whether there's any other instances where silence, could be indicative of acceptance. If I'm talking too fast or any of this doesn't make sense, or you're sort of just sitting there like, what the hell, let me know. Otherwise, once you've identified the areas that need to be discussed, you should consider whether there's any, possible defenses that the other party could use or counter arguments that they might put forward. This is really important because it's sort of your chance to show your lecturer that you've considered it from different perspectives. And it means you can kind of give, if, for example, it's a letter of advice, you can kind of give more specific advice to your client. In this instance, you might also like to consider, if you're sort of looking at the relevant case law for each particular, or the relevant legislation for each particular thing. Actually, no, I'll talk about case law. If you're looking at the relevant case law for your particular area of law, you might also want to consider any differences between your case and sort of like the current accepted case law. That way, so if you're sort of going through your lecture slides and looking at, the key cases your lecturer has suggested, you can rule out points that are not relevant. So, for example, if you're discussing whether silence constitutes acceptance, but there were other accompanying actions, are there cases that you could discuss where there was silence but no other, accompanying actions, or cases with other accompanying actions? These might both be helpful in your discussion and mean you can kind of draw, there's nice comparisons between your case and the current accepted case law. Lecturers love that stuff. Absolutely love it. And you'll get a better, you will get better mark if you can sort of show your, clear understanding of the law there. Once that is all done, view each and start collecting all of your case law if you haven't already done so. Does that make sense? Does anyone have any questions at this stage? I'm gonna assume it's okay because I can't see anything in the chat.
No, that's good. Thanks, Jess.
No one's dying yet. Just me, it's fine.
All really good. Thanks so much. I'm appreciating it. I'm sorry that
No.
you're not getting the positive feedback that I feel in my heart.
Otherwise, on this lovely slide here, this little bad boy is sort of an example of how you might collect your information. So this is a contracts one. So it's did the parties conclude the written agreement? Yeah. And then you want to identify the relevant terms of the agreement. Has there been any breach? Obviously, this is another contracts one, but this is sort of how you could set it out if mind maps work for you. If they don't, you can just write it out however you like. I personally like to write dot points just because dot points make sense in my heart, guys. Otherwise, we'll go on now to sort of how you should structure your letter of advice. I will talk about how to set out a memo as well, but I'll sort of do them separately just because they're same, but just slightly different. Start with a letter of advice because they're usually easier. So when you want to start your letter of advice, when you're actually, you've written it up and it's all nice and pretty, this is pretty much what the top's going to look like. You're going to have your lovely little fake firm because it's a letter and we put, where the letter has come from. I like to use 123 fake firm, but it's up to you. You also want to make sure you have the addressee's details. So this is your client. If you've got this information, put it in. And then at the top of your letter, you're going to have, if your client is Ms. Amanda Peachtree, you're going to have Dear Miss Peachtree. If you're in this one, if you're unsure if it's a Ms. or a Mrs., I would always recommend just put Ms. It's going to be safer bet. But otherwise, if you sort of don't want to use, if you don't want to use the titles, you can just put the full name. Now, shortly under that, we've sort of got this little subject line here. So it's like clear and concise summary of the subject matter. Depending on what your lecturer likes, you may like to put this subject line above and just put it in here. I personally do because it makes more sense in my head, but it's up to you. Hopefully that's going to go to the next slide. All right, so directly after you've got either Ms. White or your subject line, you're going to do your introduction. You will see a nice little thing that says don't use these as your headings. Because basically you want to, like, your headings want to have a logical structure. You don't want something that says introduction, body, conclusion, because your lecturer is going to look at that and be like, what's that? Having said that, if you have a lecturer that says put specifically intro or introduction at the top, I would do it that way. But otherwise, basically, your letter is going to have an introduction. You might have a brief summary of the facts in there. This will change depending on the lecturer, and I know that's really frustrating, but some lecturers really like having a brief summary of facts, some don't. As a general rule of thumb for myself, for a letter of advice, I don't normally put a summary of the facts unless it's unclear and there's some weird little things in there, or you're sort of going to be referring back to the summary throughout your letter. And the reason I don't normally do it is because when you're sending a letter of advice to a client, they know what's happened, they know the facts. But it's sort of, if your lecturer says you should include it, just include it. Your body is going to be where you break down all of your issues, and then the conclusion is literally just going to be a summary of your finding. For letters, this is usually going to have some sort of like preliminary advice to your clients, you know, depending on what it is. You know, it might be you need to turn up for court on this date, you need to tell me how you want to proceed, you need to tell me, you know, if you want to sue this person or if you want to go ahead and set up another meeting or whatever it is. Alrighty, this is sort of a bit more detailed, I guess, about what's in the introduction and what's in the facts. So in the introduction, I would normally say something like, you know, thanks for your time on the phone on Thursday, or thanks for coming into our office on the 25th of July 2020, whatever it is. So just you thank the person, you know, for either speaking with you or for meeting with you, reference the date if you have it. And then you would state the reason why you're writing to the person. So, for example, you can say, the purpose of this letter is to explain your legal liabilities in whatever. Once you've explained why you're writing to the person, you can then sort of provide a summary or an explanation of anything, you know, the person might need to do next. You can include that in the introduction, or you can include it at the conclusion. It's sort of up to you. Otherwise, you're sort of like we discussed before, you can have a summary of your facts. If you are putting facts at the top, make sure it's in chronological order. So sometimes when your lecturer gives you an assignment, the dates will be all over the place. When you set it out, I would strongly encourage you to make sure it is in, you know, date order, so that it's nice and clear, you know, this happened on this date, this happened on this date, this happened. Alrighty. Now we're into the fun bit. So this is the body of your letter. When you're looking at the body of your letter, this is where you're going to get most of your marks. So this is where you want to spend most of your time and most of your word count. You want to use headings and subheadings to make sure that you're guiding the reader. Have a look at rule 1.12 of AGLC 4 for headings, because it sets out sort of what your heading should look like at each structure. So it's sort of like, you know, your overall heading should be, I think it's capital letters in the center of the page in bold, or, you know, some crap like that. And it sort of sets out, you know, each level and each subheading, what that should look like. So it's clear, you know, it's clear to your reader, you know, this issue comes under this heading, that kind of thing. For your paragraphs, you want to make sure you are addressing one point of law per paragraph. So the example I've got here, you know, you don't want to be talking about if it's torts, you don't want to be talking about trespass to person and trespass to land in the same paragraph, because they've got different legal rules. So you want to set them out separately. I've got a little note here to say structure each paragraph using IRAC. We'll get into IRAC in a second though, don't stress. Otherwise, in nice and bold, use plain English. Like I sort of said earlier, there's no point writing, you know, a super fancy letter to a client if the client's not going to understand what you're saying. It sort of defeats the purpose of a letter to a client if, you know, you're using lots of legal jargon and lots of really complex vocabulary that, you know, they're not going to understand. For example, if you get something where, you know, I've had a question in torts where the client had a head injury. If I'm sitting there using all of my fabulous vocabulary, which isn't that fabulous, but, you know, if I'm using all of my nice big words that I've learned, that's not going to be helpful for them and they're not going to understand. And if it's a letter, you're going to get marked accordingly. Otherwise, also include your counter arguments. When I say counter arguments, it's sort of if you're writing, for example, if you're writing a torts thing, you could say, you know, you might be considering this, but the other side might argue this. And that's sort of what you want to get down into when you're doing your IRAC stuff, but maybe we'll touch on that in a second. Alrighty, and then would you believe it? You're going to sum up your letter of advice with a conclusion. You can, it depends sort of what your structure looks like. When I'm doing a conclusion for my letter, I normally title this section next steps. But literally this is just to tie everything up into a nice neat bow for your client. So you want to do things like advise on the likely outcome, or if there's something in the case that's not clear and you need, the client to give you more information or to tell you something, that's where you're going to write that. So if they need to do something, you tell them what that you need them to do. You also want to, when you're sort of giving advice, you want to provide a realistic outcome. Sometimes you'll look at a case and you'll look at your problem question that the lecturer has given you, and there will be no way that that client is going to win. If you come in that being overly confident and you write down that, don't worry, I will get you off your murder charge. I know you stabbed them 20 times, but just don't even worry about it. I got you. Your lecturer's going to look at that and go, that they've clearly misunderstood. So you just want to make sure that you're, not being too overly confident, but at the same time, you still you want your client to come back, so you don't want to be like too negative. It's it can be a fine balance. If I had to pick one, I'd go with the don't be overconfident. Because your lecturer won't like that. I've also got sign off with yours sincerely. Personally, I use kind regards for my work email. It's a personal thing. Some lecturers have said to me, you always use kind regards. Some have said, use yours sincerely. If they mention one in class, use that. If not, I would just go with yours sincerely. Does that sort of make sense? That's roughly the end of the structure of a letter of advice. If anyone has any questions about any of that, I'm going to assume we're all good. No one's dead yet. All right.
I actually have a quick question.
Yeah.
When you're doing counter arguments, do you personally like to fold them into exactly when they pop up, or do you sort of do it after in a different paragraph?
So I do it in the same one. When we sort of talk about IRAC, perhaps we can talk about it more then, but basically the way like I would set out an overall argument is literally like, I'm assuming you guys have used IRAC before, where it's sort of like issue, rule, application, conclusion. The way I do it is sort of, set out what the issue is, and then set out the rule. And I set out exactly what's happened in this case and why I think, you might have a particular conclusion. And then I would say, conversely, the other party might say, X, Y, and Z because of this law. And then I would explain either why that's right or wrong. Does that sort of make sense?
Yeah.
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 I would tackle it under each issue.
Right, because I guess you don't want to spend tons of time on the counter. You just want to mention it so that they're aware that it's there, kind of thing.
Yeah, and it's sort of like you want to, because I guess ultimately at the end of the day, like these letters aren't being read by a real client, they're being read by your lecturer, and they're the perfect opportunity to show your lecturer that you've understood the content, and that's why you sort of want to fold it into the body, because that's where they're sort of, that's where your lecturer is going to spend most of the time reading, right? Reading what you've said and what you've understood. And if you can sort of show that, yes, I've considered, they might say this crazy thing, however, it's not true because, or, it doesn't apply because of whatever reason. But I agree, I wouldn't spend as much time on it as I would on the actual issue.
Thank you.
Yep. Alrighty. All right, so we'll talk about, does anyone else have any other questions? If you do, it's totally fine, or you can email me later, either way. All right, so memos, really similar to, or relatively similar to a letter. They're going to be a little bit more formal. The language that you're going to use is going to be slightly different. But basically, the top of your memo is going to look like this. It's going to say it's a memorandum of advice. You're going to have something about your firm's details again. So, 123 fake firm or whatever you've got. And then you're going to specify who it's to. That should be in your problem question. Similar to when you're writing a letter to a client, I probably should have mentioned this before. Make sure you got the spelling right, because it's really embarrassing if you don't. It's such a small detail. But if the lecturer sees it, it'll just like set them off. But yeah, you want to say who you're writing it to, put your name, and put the date. I usually just put the date the assignment's due because that's usually when I'm writing it anyway. And then in the same, in the same kind of vein as your letter, you want to have a subject. And like the subjects is usually, really quick things like advice on possible murder charge, something like really short, really snappy. You don't want it to be any more than that line. If it is, you've probably overshot and you just need to rein it back in a little bit. But yeah, that's what the top's gonna look like. All right, and then right under that, you're going to get straight into it. So when I do a memo, a lot of the time you can have an executive summary at the top, and an executive summary is literally just, it's the conclusion. It's literally the conclusion. It's, straight to the point. This is pretty much the crux of the issue. And the reason we put that at the top, if this is a real law firm or a real job, no one reads the lovely work you do. They want, they want the cliff notes. They want exactly what the issue is. And so you sort of put it at the top. But this is basically your conclusion. Like I've sort of said here, you can write it last. I often do, but I sort of leave space for it as I'm writing. And then depending on who your lecturer is, you will have a facts and assumptions section. You can have facts and assumptions separately. The reason I would normally put facts in a memo is because, say, for example, you're giving this to, your instructing solicitor or whatever it is, they don't know the background. And so that's why I'd normally put it in. Courtney, though, you have a question.
Oh, I was just going to ask about the executive summary. So are you basically saying if you write that last, that in that you would put your conclusion?
Yeah. Yeah, okay. So I literally put my conclusion at the top.
And so it would be like, this is what I feel will happen, or like, this is what I believe or the outcome could be with my analysis below. And then below there might be, other things that could occur, but like what you essentially think will occur and your absolute advice is at the top. Am I?
Yeah, that's how I normally do it. I will say, like this cute little speech bubble in the top says, this is a guideline, and technically, there is no way to do it. I mean, if you go between different law firms, they'll all have different structures and how they write it. In terms of my assignments, though, this is how I do it, and this is how a lot of people do it. And the reason you would do it in real life is literally, like, honest to God, it's because no one reads anything. They don't care. They just want to know the answer. No one cares about your lovely, structure and reasoning and how you got to the answer. They just want the answer. And so, yeah, you're exactly right. I would put things in there like, if it was a criminal law question, I might put something like, Jessica is likely to be found guilty of, I can only ever think of murder. Jessica is likely to be found guilty of murder because of X, Y, and Z. And that's sort of it. Keep it nice and simple.
All right, thank you. That's great. Thank you.
Easy. And then facts and assumptions, same as always. So only the legally relevant facts. If there's something in there about, in the particular situation, the client likes to eat Pop-Tarts, probably not factually relevant, probably wouldn't put it in there. But if there's something, on this particular date, Jessica signed a contract, it's probably relevant if it's a contracts one. And you want to put all of those in, make sure they're all in chronological order. Otherwise, that's sort of it. And then you're going to get into your issues. And your issues, would you believe it, is where you're going to spend most of your time, because that's where you're going to do all of your analysis about what sort of actually happened. It's where you're going to be breaking down, all of the legal issues and all of the questions into little subcategories. Otherwise, in this one, we've kind of said that you can present as numbered questions, starting with what's most important. I don't normally do that. I sort of normally set it out in a similar, if, for example, it's a contracts assignment, I would set it out in a similar format to how the content in class has been presented. So contracts, they always start with, offer and acceptance. I usually start with that at the start because it's going to be the first thing, and then sort of work from there. I'm just double checking, Courtney, do you have another question?
I don't. Sorry, do I need to put my hand?
No, that's
No.
okay. I can just see it and I'm just like, oh no.
Oh, sorry, I'll try to work that out. I don't need to. Okay, I'll work it out.
But
Just
otherwise, with these kind of things, particularly with the facts and assumptions, more often than not, your lecturers will tell you whether or not they want that kind of information in the lectures and tutorials. They'll make some kind of snide comment about it, and you should be able to pick up whether or not they want it. If you are unsure, just send them an email. Just be like, hello, do you want this information? Yeah, just to sort of make sure that you're not wasting your word count if you don't need to. Alrighty. Step 4, drafting your response, guys. So this is sort of your discussion and analysis. Literally under each issue, this is where you're going to be doing your discussion and analysis. You need to do this for each point of law you're going to be talking about. This is literally where you get the most marks. And it'll literally be where you're sort of stating the relevant law and how it applies to your situation. So in terms of the structure, so sort of like I mentioned before, so you want to structure each paragraph as its own separate point of law. I generally would recommend structuring the paragraphs using the IRAC method. But in the paragraph, you also want to make sure that you are including cases. So you want to find cases that, have similar facts to your clients or, whatever's in the problem scenario. You want to discuss how that case relates to the particular circumstances. In some instances, you will want to group similar cases, and you will also want to distinguish on cases that have sort of different facts. And sort of like we were discussing before, you do want to make sure you're considering both sides of the argument so that your lecturer knows that you were listening in class. And then you want to make a conclusion. Usually, the easiest way to decide a conclusion is to consider how similar cases have been decided. And you sort of want to give some kind of an opinion on, the strengths and the weaknesses of the client's case. Just move to the next slide. So I love the little slide about IRAC. If anyone has sort of specific questions about IRAC, we can sort of talk about it here. But basically, your lecturers harp on and on about IRAC. It is a really good way to structure your answer for each sort of individual issue that you will tackle. Having said that, when you have written your answer as a whole, you don't, and you've written out your lovely letter and it's all really pretty, you don't want to have subheadings that say issue, rule, application, conclusion. It should be really clear from your writing, this is the issue, this is the rule. So the issue will sort of, be similar to the heading. If the issue is about whether a contract has been accepted, your heading might just be acceptance, but the issue is, was there acceptance in this case? And then you want to move on to the rule. A really simple way to do the rule, if your lecturer has said in one of the slides, this is the rule for acceptance, you want to have that in there. So your rule will just be the definition from the relevant case law or the legislation. Worst case, I would really encourage you to make sure your rule comes from a case law or from some legislation. Worst case scenario, if your lecturer has said, this is where the rule comes from, and in the JD, in advanced contracts, there's some instances where you might refer to certain textbooks, but that's the only time. So if there's no case law and there's no legislation and your lecturer has quoted a textbook, you could use whatever definition is in the textbook as your reference. Does that sort of make sense? Just reference the case law, reference legislation. That's where your rule comes from. Just on the rule, you can sort of word it in your own way to say, what rule would apply in this situation. You don't necessarily have to include, as in the case of Carlil and carbolic smoke ball or whatever, you don't have to say as in the case of this. You can just say, this is the relevant rule, and like just explain the rule. And then at the end, you can just footnote the case and the pinpoint, if you have a pinpoint. That's how I normally do it if I'm running out of words and I don't want to include case law. I just say what the rule is and put the case in the footnotes. Otherwise, moving on to the application. So the application is literally just how the rule applies to the current issue that you're discussing. This is where you're getting a lot of marks. So if, for example, you're talking about, if we go back to the acceptance and if we're talking about whether there was or wasn't acceptance, and the fact scenario says something along the lines of, I walked into a store, the salesperson said, would you like to buy this for $10? And I nodded. You could probably, talk about silence because I didn't say, yes, I accept. But then you'd say something along the lines of, this person nodded. And then you refer that back to the case. So similar to this case, nodding can be acceptance. Does that sort of make sense? So basically you're referring it back to whatever's in the problem scenario about what specifically they did that refers to that rule. Hoping that sort of makes sense. And then from there, you're going to have a conclusion. I think this is, somewhat self-explanatory, but basically you're just tying it together and making a conclusion about whether or not this particular rule has or has not been met in this instance. And you can summarize whether you think you've got a strong case or not. Does anyone have any questions about that? I might just introduce a different way to think about it if IRAC isn't really your thing. And this is sort of, I guess, a structure that I often use, but basically it's deductive logic. If you've done any English training or anything like structure and logic training, anything like that, you've kind of got, there's two different arguments you can make. It's either inductive or deductive. Usually for your classes like crim, torts, contracts, that kind of thing, you're going to be using a deductive logic. And basically what that means is you're going to be looking at the specific rule. So it'll be a rule, or if you're writing for something else, it might be like a general principle or like a universal truth that everyone accepts. And then you're going to be looking at exactly what happened in this specific case. And then from that, there's only ever going to be one logical conclusion. And that sort of makes up the synthesis of the argument. And I guess like the easiest example is a rule that we might all accept is that, for example, all humans are mortal. In my specific case, we would say, well, Jess is human. And then the only logical conclusion you can get from that, is that if all humans are mortal and Jess is Jess is a human, Jess must be mortal. So it's literally, this is the rule or the law or like the case law or the legislation. This is the rule. This is what happened in this specific case. You refer back to whatever happened in the problem question, and then you say this is the only logical conclusion, and you sort of do that for each issue. It's the same as IRAC. It's just a slightly different way of saying it. Have I lost anyone? Does that not make sense? Does anyone have any questions? No, I feel like we're all okay. That's all right. Let me know if you do have any questions, guys. On the next slide, I've got an example of a good, trees.
Hi guys. So what's the other word that you use? You use deductive logic, and what was the other one?
So you've got deductive logic and inductive logic.
Inductive. Okay.
Yeah.
Yep.
Inductive logic, you won't use it as much. I don't think you'll use it as much for law school. You might use it for essays, but basically what inductive logic is, so deductive is literally, this is the rule, this is what happened, this is the only logical conclusion. But inductive logic is sort of where you've got lots of different little things that have happened. And if you add all of them together, you can get, a conclusion, and it'll usually be like a conclusion that's on the balance of probabilities. So I don't have a law school example, but I do have a telco related example that I'll tell you really quickly, just as a tangent. But for example, if I was looking at a fraud complaint, so if I had a consumer that called up and said, yeah, someone has opened all these accounts in my name, it definitely wasn't me. But then I look at all of the information to decide whether or not it is or isn't fraud. But then the information is things like they signed up for a like an NBN service at their home address, and then they give me information to show they've been paying for it. And then I look at like a call recording and it's the consumer who's called up, to order it. If I kind of look at all of these sort of separate things, those things, individually, they might not be enough to say, yeah, 100% that's what happened. But if I sort of add all of them together, it leads to a conclusion on the balance of probabilities. I wouldn't worry too much about that for law school. Most of the time for these kind of things, you will be just using, it's literally just applying the law, and it'll just be like, for there to be acceptance, this is the rule, this is what happened in this case, therefore there was acceptance. And that's sort of how you would do that. Easy. All right, I've got a nice little example of a couple of not so great IRAC answers and one pretty good answer. Because it's sort of 10 to 8 and I don't want to keep you guys forever, we'll go through it super quickly. The first one is literally just, it outlines nice and clearly what the issue is, but it has no application about, the rule or the law or anything like that. Kind of just goes straight to a conclusion-ish. If you have a look at the second one, that kind of just says the rule, I think, ish. But has no case law or anything like that. That's cute little graphics. Yeah, that one's not great. Otherwise, if you look at the third one, it sets out, the first issue is whether the parties concluded a written agreement. The agreement to be concluded, the offeree must communicate acceptance of the offer to the offeror as indicated in this case, and that's your case law. So that's your nice little rule. And then you say, as Jessica, the offeree did not return the written contract to Roger, the offeror, or in any way indicate to him that she accepted the terms of the written agreement, the contract was not concluded by way of written agreement. It is therefore necessary to consider whether the parties have concluded an agreement by other means. So that sort of, sets out, this is the issue here. Was there, a written agreement? And then it sets out the rule, and it has a case that goes specifically with it. So that's where the rule comes from. We haven't just made that up. And then this is exactly what happened in this particular instance. So this is the conclusion. If that doesn't make sense, let me know. I'm going to assume everyone's okay. But if you're not, let me know. Or if you don't want to put your hand up now, just email me later. I'll pop my email in there. We do have an example of a letter of advice. We'll release the slides afterwards and you can sort of have a look at them in your own time. They do come from Effective Legal Writing, a practical guide. They're available in the library resources, which is very helpful. Thanks, RMIT. But otherwise, cleaning up your draft, making it pretty, just a couple of really, really simple stuff to make sure, just as you're wrapping up. So the first thing is, and like this sounds so obvious, but make sure you've answered the question. I find this really difficult in essays. I often go off in like nice little tangents. Don't know if you've noticed, it's just how my brain works. But you want to go back and make sure you've actually answered the question. You also want to make sure that you're going through your draft, cleaning up all these sentences, and making sure that none of your sentences are too long or not clear. if you're unsure if a sentence is too long, I mean, the easiest way is to read it out loud. If you can't read it out loud in one breath, it's too long. If it goes over 4 lines, it's probably too long. Or I mean, if it goes over 3 lines, you're definitely getting up there. Or if you are like me and you cannot stand reading your own work over and over again because it gets really tedious in law school, in Microsoft Word, if you click on the review tab, you can then select read aloud, and it'll just read it out loud to you. And if you're kind of listening to it and you're like, that sounds whack, I have no idea what's going on, then you know that you probably should just try restructure. Yeah, so the read aloud is like super helpful, especially when it's like 3 a.m. in the morning and you're like, what is going on? Otherwise, you want to make sure that you're writing in an active voice, and just yeah, I would always encourage you not to include legal jargon. There's some lecturers that just love it. Like, I don't know if many of you have Tim for intro or constitutional, but he loves using things like inter alia, just say among other things, whatever. But otherwise, you also want to make sure that, you know, if there are possible remedies or, you know, things that the client needs to do or whatever it is, you want to make sure that, you know, you've included those. So having said that, though, you do want to make sure that you're not sort of doing those sweeping statements, things like you will definitely get compensated, or you're entitled to damages if it's, you know, if it's a torts case. You don't want to overpromise, but you want to make sure that you have discussed it. Where you can, make sure you're, you know, including your counter arguments. I will add, counter arguments, you're not going to make, you're not going to have them for absolutely everything, but it's good to discuss, you know, conflicting cases, particularly if you have, you know, enough room in your word count. Otherwise, if you're sort of, yeah, otherwise, I guess, you know, the most important one is probably making sure that, you know, you've adjusted your language appropriately for whether you're writing like a memo or a letter. A letter for a client, just nice, short, sharp, direct sentences, tell them what they need to know. They don't care, you know, about everything ever. But if you're writing to a barrister, you know, and the idea is they're supposed to be presenting it in court, they're probably going to want to know the nitty-gritty of, you know, the particular cases. I will also say, so AGLC, if you don't have a copy of the AGLC, I'll pop a link in the chat, but if you, yeah, so if you don't have a physical copy, you can use that. It is your guide. It will, no matter what you want to cite, it will have a way to reference it. So, you know, there's like particular ways to reference Canadian legislation, and, you know, whatever random crap you need to, you know, you might ever need to reference, it will be in the AGLC. So I'll pop that in there. Otherwise, you all know, proofread your work. Just kidding, I never proofread my work. No, definitely proofread your work so that you don't have spelling errors like that where it says proofread. That's supposed to be one word. Otherwise, some nice little common mistakes. Don't use contractions. So can't, don't, won't, don't use them. Otherwise, check your word count. If you sort of are sitting there looking at it going, how did I get that far over the word count? Also, make sure you untick your footnotes. So you're not counting those in your word count. Footnotes shouldn't count for your assignments. It's very rare that they will count. And if you sort of have an assignment that says footnotes count in the word count, I would email your lecturer straight away and just make sure that they didn't forget to proofread the assignment before they put it out. Otherwise, with your word count, 10% above or below is usually okay. If you're finding yourself going massively over that, or you're massively under the word count, if you're massively under, you've missed something and you need to go back, you've missed some law, go back through your lecture slides, just check you haven't, you know, forgotten to add something in. If you are massively under and you think that, oh, sorry, Therese, did you have a question again? I'm so sorry.
Yeah.
I'm so sorry.
No, all good. With the untick word count, where do you locate that?
Yeah. Do you know what? I can show you. I'm just going to put this document here. So say this is your document and not at all my script of the slides. If you click on words down the bottom, it'll pop this little bad boy up and you just click include or don't include. This one doesn't have any footnotes, so it doesn't change it. But that way you can make sure that you're not sort of, that you're not including your footnotes in the word count, because like honestly, there'll be some lecturers that will accidentally leave it in there to say the footnotes are included in the word count, but they very, very rarely will be counted. But if you just tick that little box, so click on words down the bottom and just untick it, it'll take out all of the word count in there as well. Otherwise, oh yeah, word count. If you're massively under, go back, check you've missed something. Even if you think something doesn't apply, if you're really under the word count, I would just put it in there and say, you know, this is this particular law, this doesn't apply, this is why it doesn't apply. If you're massively over, you've probably either put too much, like too much direct copying from like case law or something like that. If that's the case, go back, summarize it, you should be able to make it shorter. Or you've covered things that are not at all relevant. Very occasionally, the lecturer will just not have given you enough words. Doesn't happen that often, but yeah, if you've sort of gone massively over, just go back through and cull what you need to. One of the other things, I mean, you'll get this everywhere, just check your grammar, check your spelling errors. Lecturers get really annoyed when they can't read your sentences. Trust me, I know. Otherwise, if you've introduced any ideas, if you've introduced any law or any, you know, possible ideas, make sure that you go through and answer that. Otherwise, it'll be weird. Otherwise, I like this one. Don't assume your reader is an expert. So you do want to adjust your advice accordingly for your client or your barrister, but you want to explain what the law is and how it ties into that particular case, because that's literally where all your marks are. Otherwise, I feel like all of the rest of this is pretty self-explanatory. Don't add new facts in the conclusion. If you find yourself adding new stuff in the conclusion, it's probably in the wrong spot. You probably should go back and make sure you've included it somewhere. Otherwise, I think, oh yeah, simple ways to boost your memos, guys. All right, so have a consistent size and a consistent font throughout. Do 1.5 spacing. Do all of that stuff at the end. I literally Control A and select all of the text, make it all the same. Do that for your footnotes as well. So make sure it's all the same size and all the same font. Just a really quick tip for making sure your footnotes look finished and polished, even if maybe they're not. AGLC 4 says every footnote should have a full stop at the end. So I always go through and make sure everything has a full stop, because even if maybe my footnotes aren't perfect, at least a full stop will make it look like you've gone through and made sure everything's perfect. So if you have a teacher who doesn't check the footnotes particularly well, that could be really helpful to make sure it looks good. There is also if in your footnotes, I'm sure you've gone through this already, but if you're referencing the exact same case or legislation that you've referenced in footnote 24 and you're referencing it again in footnote 25, if it's directly afterwards, you can use IBID. So yep, so that's good. Or if you're using a particular case 3 different times, the first one you can use the, I don't know, I'd call it the N rule. I think it's got another name, but you sort of just give it a short title and you can go throughout. That stuff's in the AGLC 4 if it doesn't make sense. Otherwise, I'm pretty sure got some resources. They'll be on the slides. And that's it. We made it, guys. 2 minutes under time. What questions do we have?
Well, I have a quick question about IBID. So,
oh yeah,
can it be used? So, say you've referenced something on the first page, and now you're on the second page of your own work. Does it reset, or do you still use IBID to refer to something on a different page?
Yeah. So if you've got footnote 21 on the first page and then 22 on the second page, if it's the footnote directly above, you still use IBID.
Oh, so it needs to be directly above.
It's got to be direct, like the footnote directly above. If you want to. Yeah, if you want to do, if you want to refer back to a case or, legislation that you've already referred to, the way you do that is,
Was that what you were just talking about? The
It's
N?
the N. Yeah,
Yeah,
it's the N rule.
Discovered that in my last assignment where I was like, oh, the N
Yeah.
reference.
Yeah, and basically
But
all
yeah,
that is like the first time you talk about Australian consumer law, for example, you would write out the full reference. So for the ACL, it's like.
but then don't you also give it a nickname
At the end?
Yeah. Yeah, cool.
Yeah, so you put the full reference, including, you know, your pinpoint, and then at the end, in brackets, in single quotations, you give it a nickname. Usually it's going to be like, if it's a case, it's the first name.
Yeah.
And if it's like a popular case, for example, in Constitution, you've got one like the work choices case, that's really big. You just call it work choices. Even though that's technically, in that case, it's the second name. So it's either the first name in the case, the popular name. The only other time you wouldn't reference the first case is if the first case is the Crown, like RV or the Crown v. But yeah, put a little nickname at the end. And then when you're sort of, you know, referencing it, you know, at footnote 50 or whatever it is, you would put the short name, and then in brackets you do N, whatever the first reference number, and then the pinpoint. Yeah, it'll save lots of time. No, it won't save lots of time. It's fiddly when you do it.
It's so fiddly.
But it makes it shorter. Personally, I'm not a fan. I'd much rather put like of this rule. I'd much rather put like the full case name the whole way through.
I was gonna say, like, so would you lose? So like in my last assignment, I discovered this rule and I was all about like the N rule. And I found it so fiddly. Would you actually lose marks for just ignoring that rule and then just correctly restating the case?
Yeah, it's a good question. This is a really shit answer. It depends. So James, who teaches like contracts B for the JD, he had just finished doing his own legal submission when I did contracts, and he had to go through and make sure everything was perfect to get it submitted. So when he was marking our work, he was like, this will be perfect. And when we didn't use that rule, he was like, and marked us down. But there are other lecturers who just, obviously this is recorded, who aren't particularly fussed about it, and they won't mind.
Okay.
So
I was doing it, I was like, this is so fiddly. Can I not do this? And then I did it anyway, but then I wondered if I could get around it.
Yeah, it's one of those things, like some lecturers won't mind. Lecturers like are you in the JD? Sorry.
I am, yeah.
Yeah, so like Vanessa for property, she checks every single one of your footnotes. She cares. But like there are others that just don't give a shit. So personally I would do it, but I'm fussy. The reason I do it is literally because grammar and footnotes is generally 10% of your mark, and so it can very, very easily be the difference between, you know, a credit and a distinction, or a distinction and a high distinction. So it's like it's such a small thing, but
get marks.
Exactly. It's a nice easy 10%, and I mean, having said that, I leave my footnotes till the end.
And then you yourself on that last day.
It always takes longer than you think. But I would encourage you to use it, but also what else? Otherwise, the other thing I'll add here, so this one here where it's like use the reported citations. So for example, it's got CLR, not HCA. There's a really easy way to check if there is. So HCA is like the High Court of Australia, right? CLR is Commonwealth Law Reports. So that's like the like the proper citation. That's the one you should be referencing if it is in the law reports. And the best way to check that is literally just to go to Westlaw, tap case in, and it'll tell you if there's a CLR in there, and you should be able to download the case if you need a specific point. The only reason I know that is because I've just done a contracts moot, and I had to go through 83 footnotes and get the CLR for each individual one of them. Otherwise, how are you all doing? Does anyone else have any other questions? If there's no questions, I might just stop the recording.